please step up.
Yes, Chief Justice, it may please the court. My name is Michael Brown, pro se, the defendant. I'm principally here on convictions for unlawfully prescribing controlled substances, Medicaid fraud, larceny, and a possession complaint. I was indicted for distribution or dispensing, which is my principal issue, convicted of dispensing. On appeal, the appeals court was affirmed for dispensing, and presented to this court, there was a reinterpretation of this dispensing statute to say it principally involved lawful conduct, in that dispensing conviction was converted to distribution. Now, having been indicted for distribution, during trial for distribution, at jury instruction, the trial judge asked the Commonwealth, the prosecutor, which charge is it? And then specifically, is this a distribution case? The Commonwealth replied, Common says it's just dispensing. At which time, the judge instructed the jury that the word distribution is surplus. The only question before you is whether this defendant unlawfully dispensed controlled substances. Now, I think in form and in substance, that is an acquittal of distribution after the jury is discharged. The Commonwealth had ample opportunity to refute this or to contest this jury instruction, but in fact it endorsed it and approved it. Now, the double jeopardy clause of the Fifth Amendment to the U.S. Constitution clearly prohibits the re-examination of a pre-verdict acquittal. There are numerous cases that bear that out. One of the recent ones is Melvin Smith versus the Commonwealth, where the court says that not only is it not up for appellate review, it's not even reviewable by the initial trial judge. And in my case, where an issue was never in contention, on the Commonwealth's brief, you will never see in their statement of the case the word distribution. I assume there's an assumption that the distribution charge had been resolved, only to come here and find that it's been reinstituted. And secondly is that the Commonwealth elected to proceed only on
Could I ask you about that, though? The Commonwealth, in seeking jury instructions, never sought jury instructions that suggested dispensing was dispensing to a lawful, for lawful purposes, to a lawful, a lawful prescription to a patient for lawful purposes.
That is correct. It was specifically an unlawful delivery.
Which is what distribution is.
Distribution, correct. But that would still be an opposite, because that charge has been resolved. When the judge informs the jury that the word distribution is surplusage, if no matter in this case, what else could that possibly mean? In one of the federal cases of Price versus Vincent in 2003, Justice Rehnquist goes through what amounts to the finality of a judge's ruling. In quoting from a case in Michigan, he says there are three significant indicia of finality. One is a clear statement in the record or a signed order, and an instruction to the jury by the judge that a charge or element of a charge is dismissed, or a docket entry. At least two of those are present inside this case. There's a clear statement inside the record, and there is an instruction to the jury that the offense of distribution is no longer in contention. Now, after that, the charge of possession, along with the charge of dispensing, in Perry, they made very clear that possession is a lesser-included offense of distribution, dispensing, manufacturing, or intent to do any of the above. And again, that seems to me is not appropriate to be charged with and convicted of both. And those are pretty much my main issues here.
All right, thank you very much, sir.
May it please the Court, Assistant Attorney General Todd Bloom for the Commonwealth. This Court should affirm the denial of the defendant's motion for release from unlawful restraint. Your Honors, this is a case where the defendant is in effect asking this Court to rule that it violated his federal constitutional rights when it affirmed his conviction on the theory that he unlawfully distributed controlled substances. And all the defendant's claims center around a common theme, and this theme seems to be that proceeding on this dispensing theory during the proposed jury instructions resulted somehow in dismissal or an implied acquittal of the distribution charge. This is not the case. As this Court stated in its prior decision, the defendant was indicted for both knowingly or intentionally distributing or dispensing a Class B substance. This is what the jury deliberated on. The distribution charge was always in contention. The Commonwealth never null-prossed or dismissed out that distribution charge as the defendant claims, and this Court found the trial judge instructed on the elements of distribution without using that term. So this is simply a case where the trial judge misspoke and used the wrong word, and that this Court stated in its prior decision that that did not matter to the jury. And as this Court has stated today, the word ultimate user was never mentioned in the jury instructions. So this Court simply found that the jury had been instructed on unlawful distribution and found the defendant guilty of unlawful distribution. So turning to the defendant's major claim, the motion judge properly denied his constitutional claim in this case. There has been no double jeopardy violation. Usually you have a double jeopardy violation where you have a second prosecution for the same offense after an acquittal or a conviction. Here there was no second prosecution, and I stated before, there's been no acquittal. The defendant was never acquitted of the distribution of a controlled substance charge at trial. And the indictment charging distribution was never null-prossed out or dismissed by the Commonwealth. The trial judge merely singled out a dispensing theory during the jury instructions. And as far as the possession charge is concerned, I believe that charge was placed on file, and that occurred in the jury waive trial, and we're concerned more here with the jury trial. Commonwealth would also submit that the defendant's remaining arguments are without merit, and if there are no questions, I'll rest on my brief.
All right, thank you very much.
Thank you.